poročila, ki sta ga pripravila dva prepoznavna eksperta na področju mednarodnega prava, je predvsem bil to, da postavimo ne samo politično, ampak pravno podlago za to, da spodbudimo evropske institucije za to, da se pripravijo na aktivnosti, ki so nujne po odločitvah mednarodnih sodišč, zato da se ogradimo določenih politik, ki jih izvaja Izrael v odnosu do svojih sosedov in predvsem do palestinskega naroda. Gre za eklatantne kršitve mednarodnega prava, to se tudi dokazuje. Mi želimo za našim delovanjem predvsem spodbuditi politike, da ne bomo sokrivi za to, da ne naredimo nič, kljub temu vključujoč dejstvo, da imamo pravno podlago za to. To je neka oblika izvajanja pritiska, tudi ob bližajočem odločevanju naslednji teden pri reviziji Association Agreementa, to je dokument, ki dejansko nagovarja sodelovanje med Evropsko unijo in Izraelom in seveda, da se Evropska unija končno po več kot 20 mesecih odloči sprejeti konkretne ukrepe zoper delovanje Izraela na Bližnjem vzhodu.
Ali v parlamentu vlada soglasje glede tega ali ste razdeljeni?
Soglasja ni. Soglasja ni v Evropskem parlamentu, soglasja ni v svetu. Predvsem se zdi, da v zadnjem obdobju se povečuje delež tistih poslancev in tistih politik, ki si želijo, da Evropska unija ne bo samo gledalec ali pa celo tista, ki sodeluje pri tem konfliktu in seveda spodbijanju mednarodnega prava, tisto, kar je še najhujše, genocidu samem, ali pa bomo tisti, ki bomo branili pravni red in človeškost pred agresijo.
Kakšna je razdeljenost procentualno v parlamentu?
Težko rečem, ampak mnogo argumentov, ki so jih uporabljali tisti, ki so, kot oni rečejo, razumeli početje Izraela, je vedno manj. Kajti ne gre več samo za politike, daleč od tega, že več kot leto pa pol govorimo predvsem o kršitev mednarodnih pogodb in mednarodnega prava, kar pa je v kontekstu mednarodne ureditve in mednarodnega miru zelo sporno. To, kar se danes počne na Bližnjem vzhodu, se bo lahko jutri počelo v Evropi ali pa bilo kje drugje v svetu, brez da bi kakorkoli sankcionirali tiste, ki to počnejo.
Tudi v Sloveniji ni enotnega mnenja glede odnosov oziroma nasilja Izraelcev nad Palestinci.
Nikdar pri teh vprašanjih nismo bili deležni ali pa ne pričakujemo enotnosti. Seveda vsak ima pravico do svojih pogledov, ampak mi se moramo vprašati, kaj če bi bili mi na tem mestu, na mestu šibkejšega, kajti Slovenci smo večkrat bili v zgodovini, to je naša dolžnost je kot politiki, da branimo mednarodno pravo, da branimo mednarodno, zato da v neki prihodnosti preprečimo nadaljno to isto početje. Mi bomo čez mesec dni tukaj v parlamentu obeleževali 30-letnico genocida v Srebrenici, ki je bil mnogo let kasneje priznan kot takšen. Zavezali smo se, da tega ne bomo več dovolili nikjer, nikoli več in te zaveze ne izpolnjujemo. Smo tukaj mnogi, ki trkamo na vest ne samo politike, ampak tudi držav za to, da se končno ogradimo od takšnega početja in preprečimo to vrstno početje z sankcijami.
Ali lahko kdo ste bili danes zagovorniški modri?
Danes smo bili predstavniki petih različnih držav, evropski poslanci iz treh različnih političnih družin, ki smo od februarja meseca preteklega leta tako finančno kot politično zagnali ta projekt, da dejansko ni opravičil več za nobeno evropsko institucijo, da se izogiba njeni obveznosti z implementacijo mednarodnega prava, kajti v tem dokumentu z 86 strani je jasno razvidno, da imamo to pravno odgovornost. Kolikor tega ne bomo izvedli, bomo lahko priznani kot sokrivi za to, kar se počne na Bližnjem vzhodu.
Today's event in the excellent study have been a very big effort made jointly by 5 MEPs standing here today, and especially the two experts. This is the more crucial, considering extremely tense regional situation in the Middle East at the moment. And sadly, no end of the horrors taking place in Gaza inside. The results of this expert opinion must feed into ongoing review of the association agreement, which will be discussed in the EU Foreign Affairs meeting on Monday. It is more than evident what needs to happen on Monday. The idea of this study was born from our joint disbelief from the inability of the EU to take a common position on Israel, and especially in defense of international law. This became the more evident when the leaked analysis of the ACJ opinion from the EU institution justified doing nothing. And it had precedent of the European Commission's fingerprints all over it. You cannot cherry-pick parts of the international law you like. We built an international legal system in order to prevent history repeating itself. 80 years ago, we said never again after the Second World War. 30 years ago, we said never again after the Srebrenica genocide. How can we look away from what is happening in Gaza for the past 20 months, or in Palestine for the last 7 decades? This joint effort here, therefore, seeks the accountability from the EU according to its moral, but also international obligations. And a shameful silence and inaction from the EU means complicity and also criminal liability. So here, with our words and actions, our message is clear, not in our name. The EU must wake up. Justice must prevail.
Thank you, colleagues. And now we'll hear from the researchers who join us online. So first of all, I give the floor for 5 minutes to Glede Hernandez, who is Professor of Public International Law at KU Leuven. Professor Hernandez, are you able to see us and hear us?
I am.
Excellent. You have the floor.
I hope you can see and hear me as well. Good morning, everyone. Thank you. Distinguished members, ladies and gentlemen, and dear colleagues, I'm much obliged for the opportunity to speak. Perhaps as a law professor we have misplaced faith in the power of law, but I think the interventions of MEPs Andrews, Jalloul Muro, Nemca, Strik and Søvndala have been encouraging in seeing that perhaps international law and European law continue to be relevant in these intensely political times. There are 3 basic propositions that I will introduce to structure my intervention, which is about the findings of the court and the relevant findings for the European Union as an international actor. My colleague, friend, author, Professor Bessel, will introduce the specific conclusions in relation to EU law and policy that our report and our research generated. So my 3 propositions are as follows. The first, that advisory opinions of the International Court of Justice can, and in many circumstances do, identify binding international obligations. This opinion has been studied by us, and we consider that it is one such opinion, and I'll introduce those findings in a moment. The second point is that the International Court of Justice has identified violations of such gravity and scale that in international law we call them peremptory norms. They supersede all other ordinary rules of international law, including treaty law and what we would call customary international law. Finally, breaches of peremptory norms, as we identify in the advisory opinion, can also generate obligations for third states, as well as third actors such as the European Union, especially when the European Union exercises competences on the international plane. I will introduce these general points and then hand off to my colleague, Professor Bessel. So first, a brief word on the advisory function of the court. And to give context, I think it's well known that in 2024, upon the request of the UN General Assembly, the International Court of Justice had to study the question of the policies and practices of Israel in the occupied Palestinian territory as a matter dating from 1967 and not having begun on the 7th of October of 2023. So at issue were not necessarily the armed conflict and hostilities taking place thereafter, but the very nature and legal status of Israel's presence in the occupied Palestinian territory, which I will call the OPT for brevity, and special attention drawn to the presence of Israeli settlements in the OPT, and the treatment of Palestinians and their property therein. Now, although advisory opinions are not formally binding in the sense of generating legal obligations on Israel or other parties, within international law they contribute authoritatively to the identification, interpretation, and application of international law. The ICJ is the principal judicial organ of the United Nations, and as such, over a century of practice, it has developed and continues to command a degree of heightened authority, both among states as well as expert international lawyers, academics, legal practitioners, and other judges. I'd like to give one recent illustration of the legal authority of the court, and that is the treatment of one of its advisory opinions in the question of the Chagos archipelago. This is an archipelago that had been held onto by the United Kingdom when Mauritius was granted independence in the 1960s. The advisory opinion of the court held that the United Kingdom's presence in Chagos Islands was unlawful, and although this opinion was not directly binding on the United Kingdom, a tribunal called the International Tribunal for the Law of the Sea in Hamburg determined that this finding, that the UK was unlawfully present in Chagos Islands, was held to constitute a legal binding finding that the UK was no longer sovereign in respect of the dispute between Mauritius and the Maldives. It also, within a couple of years, generated political momentum in the United Kingdom, which, as we see, is in the process of negotiating and has in fact concluded several agreements with Mauritius to finalise its withdrawal from Chagos Islands. In this respect, the ICJ's heightened authority is a matter of objective identification of existing legal rules. It is not legislative or law creative, and the court has a long history of being seen as objective, with balanced geographical representation. And I should say, when addressing a European audience, a relatively high proportion of European and Western judges, 6 out of 15. It is also a cautious court. Within international law, the ICJ is very frequently the last to acknowledge new developments. So when it speaks so clearly and identifies obligations this categorically, I believe that we must listen and take them very seriously. Before turning to the key findings of the court that are relevant for the EU, I'd like to recall the wider context in which the opinion was handed down. 20 years ago, the court determined the construction of a wall in the occupied Palestinian territory was unlawful, and this opinion structured and informed many aspects of the 2024 opinion. But it is not the same, procedurally speaking, as the ongoing case that South Africa has brought against Israel in respect of claims of genocide in the Gaza Strip, or the case that Nicaragua has brought against EU member state Germany in respect of the arms trade and its claimed aid and assistance to Israel in the commission of human rights violations and violations of international humanitarian law. Those are distinct procedures, but in many respects deal with the same subject matter, but they do so through different lenses. To turn to the findings of the court, the opinion is long. It's quite detailed and technical, so you'll have to forgive me, but I want to give a very high-level survey of the key findings of the court. The first one was a determination that Israel's policies and practices in the OPT amount to overarching annexation, de jure and de facto. This in particular applies to the settlement policy and the establishment of Israeli settlements within the OPT, the exploitation of natural resources, and the failure to prevent or to punish attacks and violence on the local population committed both by Israeli settlers and by Israeli security forces. The breadth and range of the obligations breached by Israel stretch under both international human rights law as well as international humanitarian law, which is the law of armed conflict. And the court identified in forensic detail several violations, including the forced displacement of the inhabitants of the territory, disproportionate violence used against them, the confiscation of their property without due process, and the breach of serious human rights obligations, in particular, a finding that under Article 3 of the Convention on the Ending of Racial Discrimination, of which Israel is party, that the policies and practices of Israel either constitute racial segregation and or apartheid. Though the court was not clear as to exactly which of these two prohibitions was engaged, both are, as I'll turn in a moment, of a predatory nature and generate obligations to respond on behalf of all third states and other actors. The 2024 opinion concluded that in the light of, and I quote, the sustained abuse by Israel of its position as an occupying power, coupled with serious violations of both international human rights law and international humanitarian law, that Israel's presence in the occupied Palestinian territory is unlawful as a whole. And the court indicated that it must be brought to an end as soon as possible, and that Israel is under an obligation to provide full reparation for all of its unlawful acts. The court added that Israel must cease immediately all its settlement activities, particularly the construction of new settlements, and evacuate all settlers from the OPT. And it dismissed the claim that security concerns might in some way justify or otherwise preclude the unlawfulness of these policies of settlement, annexation, and breaches of human rights. Professor Wessel, my colleague, will go into more detail in respect of the specific EU policies and programs that must be reviewed, reassessed, and changed. But as a general rule, I'm here to explain the manner in which the European Union, as an international actor, is bound by rules of general international law. These are binding both under international law because the EU exists as an international legal person.
Make your concluding remarks as you're running.
Yes.
A little bit extra time. Sorry to.
No problem. No, it's fine. I've got one sentence to go. So actually, it's perfect timing. But very simply, the EU is bound as a matter of European law, as well as it is under international law. And in this respect, it is obliged, under the conclusions of the court, to distinguish between its dealings with Israel and the OPT. It is also obliged not to recognize any claim to Israeli sovereignty or change in demographic composition or character, as well as an obligation not to render any aid or assistance in maintaining the situation created by Israel's unlawful presence. Thank you for letting me run over time. Slightly, I hand over the floor to my colleague.
No, not at all, Professor. It's very valuable to get such a detailed interpretation of the decision of the court in July. So now we go quickly to Ramses A. Wessel, who joins us again online, who's Professor of European Law at the University of Groningen. You're very welcome, Professor Wessel, for 5 minutes, if you can hear us and see us. Do we have Professor Wessel?
Can you hear me?
Yes, we can hear you and see you. Thank you.
Good. Thank you very much for allowing me to join online as well. This is the period at the University of Groningen that the students are actually presenting their final thesis, so I had to be here to listen to them as well. In view of the time, I will briefly do this, the obligations of the European Union in terms of bullet points. So allow me to go quickly to a number of things that we would like to highlight. Very first, perhaps, main takeaway of this thing would be that the EU has an obligation to at least explain how it will deal with the advisory opinions findings. So that would be the minimum requirement for the European Union to do. Second point is, you already mentioned the association agreement. Indeed, this is a very timely report, and we feel that the advisory opinion provides enough arguments for the EU to use in its review. And it would be very surprising not to see those elements coming back in the review that is now planned. Another point, and perhaps one of the key findings of the report, is also for the European Union to continue to distinguish between trade in goods flowing from Israel and from the occupied territories. We feel that although that is of course being standard practice of the European Union, there is a lot of improvement needed on the basis of the advisory opinion, which may even lead to perhaps further restrictions on goods and services coming from the OPT, or goods perhaps coming from Israel with links to the occupied territories. The other point is perhaps also to look at investment relations a bit more than has been done by the European Union before. Particularly in view of the 2013 guidelines on funding, it is a good thing for the European Union now to pick up that issue again and look at also contractors and subcontractors of those companies and institutions that have been funded. Money flows in different ways, and we have found examples in the report where we are at least in doubt whether they are in conformity with the guidelines. On visa travel, we feel that the advisory opinion provides reasons also to revisit the visa-free travel for Israelis residing in the occupied Palestinian territory. That would be for member states, but also for the European Union to reconsider and perhaps even revise those policies. Next points, and I'm going a little bit quick because I'm looking at the clock, deals with arms and exports. So the advisory opinion provides enough reasons, we feel, that member states in particular must not authorize arms exports if they acknowledge that those arms would be used to violate international human rights law. There's a Dutch case pending, as probably everyone knows, but that leads also in this direction. I would be very surprised if it would be a different outcome there. On diplomatic missions, we spent a few words on those as well. There is an ongoing policy as well. We encourage the EU, in light of the advisory opinion, to maintain that policy and not relocate diplomatic missions into the OPT or Jerusalem, or even consider doing that, because that would, in our view, be a clear violation of the whole advisory opinion. In short, at the end, what can be done by the institutions? What can be done by the European Parliament itself? I think the Parliament itself, in particular, has the possibility to challenge adopted legislation before the court in case of an infringement of the treaties. So there's a clear role for the European Parliament itself to keep a good eye on all these findings in our report and check pending legislation, planned legislation against those findings. Thank you very much.
Well, really thank you very much both professors for that summary. On the one hand, the advisory opinion itself, and secondly on the implications for the European Union. As so many colleagues have pointed out, the timing could be better in terms of feeding into the decision-making process. So let's open the floor. Are there any questions in the room? Any wishes to ask a question, such as the clarity of the explanations that questions are generated online? Yes, please. If Anna wishes to ask a question of the professors, of course.
Thank you very much, professors. We are indeed very honored to have shared this work with you. I think all of us MPs were commenting on such an extraordinary work you have done, and especially because people understand much better. Sometimes, first of all, your explanation was very clear, and also because this is super objective. I think we try to address this issue not from a political point of view, but objectively what law says. And in this matter and this regard, you are helping us to understand. My question would be that in Monday, what we are expecting the revision of the agreement, and some conclusions will be made. What do you think it might happen if the conclusions of this report related to law and that are obligatory, so the EU must fulfill obligatorily the conclusions of your report, are not fulfilled? What are the next steps after that, if things are not well done based on law and the directives for your report? Thank you.
So would either of I'm sorry, Billy has another question, and then we will go back to the experts for their reply. Billy, please.
Yeah, it's about, thank you very much to both of you. It's about the situation where there is not unanimity in the Council, where one or two countries or more are going to block, as I understood, and I just want to know if I understood it right, only the association agreement demands unanimity. But but if you only deal with trades or education, you can do it on a simple majority. Do I understand that right?
And finally, Tineke has
Yeah, very quickly, thanks for the recommendations, also that we need to follow closely and also check the current and pending legislation. But is there anything else that we as a parliament could do on our own initiative? Could we, for instance, also go to court if the council or the commission is not taking the right action in order to comply with international law? Or are there also like actors in civil society that have a ground for going to the court and demand compliance or revision of certain laws?
So we go to Leiner Hernandez for an answer. Basically, what happens if the Foreign Affairs Council does nothing, and QMB versus unanimity? Either or yours is this. Can't hear you just at the moment. Either if you can make some motivation.
You have to unmute.
We can't hear you. If you could reconnect, either with you. Vessel, perhaps we'll try with you if you wouldn't mind seeing if you could deal with any of the questions that were raised. Vessel, we have Professor Vessel, I should say.
Thank you very much. I will give it a try to see, and in the meantime, glad I can reconnect. The very first question on law, what happens if those obligations flowing from international law are not followed up? Then, as what we try to indicate in the report, that would lead to international responsibility of the European Union as such. Then the next question in international law always is, what to do about that? Can we actually sue the European Union? Can anyone sue the European Union? That is of course more difficult. We cannot take the European Union to the International Court, but luckily we have our own courts. And that also relates to the final question. Yes, it is possible for the European Parliament to bring cases to court, as it has done of course many times, but also indeed on the basis of an infringement of the treaty. I mean, international agreements concluded by the European Union, including this association agreement, are part of union law. So they can also be invoked before the courts. By the institutions, by other circumstances, even by individuals and NGOs. So there are possibilities to indeed address those issues. Let me quickly also say something on QMV and unanimity. Indeed, common foreign security policy, we're still stuck for the time being with unanimity as the rule. But this is not about foreign policy assessment in the sense that it is not a CFSP issue. This is largely about other types of external relations of the European Union. Most of it in trade is indeed related to trade issues, which indeed would imply qualified majority voting. In that sense, decision making is easier in all those areas, most of those areas covered in our report.
Okay, that's very clear. Sorry, go ahead, please. Will we try with Professor Hernandez as well, if we can hear him this time?
I hope so. Yes, I rejoined the room, I think. Thank you, I've been muted. My colleague Frances has dealt with many of the issues already, especially with respect to litigation. But I want to point out two potential forms of responses under purely international law. The first one is that although the EU cannot be brought and appear as a respondent at the court, it is entirely possible for EU member states to be brought for aid and assistance or for other breaches by other states that are disappointed or frustrated by the EU's inaction and that of its member states. Furthermore, because breaches of international law are established and exist on the part of Israel, a failure to meet obligations by EU members and the EU might allow other states or other actors to invoke those breaches and suspend treaties, suspend other agreements on the basis of a failure to comply with their international obligations. This exposes the EU and its inhabitants, as it were, to a number of potential issues if they continue to trade with Israeli settlements, for example, or if they fail to take any of the actions identified by the ICJ. Finally, private actors within the EU may rely on the findings of the court, given that the Court of Justice of the EU must apply international law, as do its member states, and may themselves take action. For example, universities might begin to pull out of Horizon Europe agreements or pull out of consortia, invoking these. Contracts might be terminated, invoking the opinion. In short, there could be a degree of legal chaos, especially if the EU's courts, and in particular the CJEU, uphold the legality and binding effect of the obligations identified in the opinion. So if the Council does nothing and the Commission do nothing, they risk being in conflict with the treaties. And by treaties, I mean the EU treaties.
That's very clear, Professor Hernandez. Matthias, would you like to make a comment?
Thank you to both of you. Just to clarify one issue, you both mentioned that it is possible to sue the institution, but what about the individuals? I mean, they are for not taking action in this case. I mean, I'm targeting the leaders of those institutions. What about them?
So, I mean, this is the Norway, Canada, Australia, New Zealand, UK are all sanctioned small church and review, which is, so would either of the experts be able to deal with this question of whether individuals can be the subject of sanction? Again, it also requires unanimity. Would either professors allow me to deal with that question? Have we lost them? Connection?
Hi, I think I'm now unmuted. Sorry. Yes, thank you. I just pushed to jump in. Forgive me, Montez. I've got two things to say about this. One is that the EU does have a practice and policy to establish sanctions, as we've seen in relation to the Russian armed intervention in Ukraine. This is a matter of EU law. And although under international law certain of these measures are in a sort of grey zone, this is entirely possible as one policy decision that is possible under international law. We do not go into this in our opinion because it is not an obligation flowing from it, but it is a choice of means. In short, yes. And the question though is whether there is sufficiently policy resolve. But I'll leave Professor Wessel-Hanses to clarify the procedure under EU law.
Professor Wessel, you there? Professor Wessel, if you're still there, we maybe get some final remarks from you. And you may well be interviewed. I think Professor Hernandez explained.
Okay.
Oh, you're back, yes. Final remarks, thank you.
Welcome back.
No, perfectly fine what Professor Hernandez said. And let me just underline that imposing sanctions is indeed seen as being, in the end, or in the beginning, I should say, because it starts with a political compromise to do this. This has not been done. But it is indeed, apart from countries, of course, we know that it is possible to also sanction individuals. So that is a clear thing. So this would be a political choice. But for the rest, most of the report will indicate it is not about a political choice. Those are strictly clear legal obligations.
Thank you.
Well, look, thank you, Professor Wessel. I hope you'll be kind and generous to your students over the next while. I want to thank our colleagues, to thank all of our assistants for all the work they did to coordinate the work and the publication. I'd like to thank the staff here and all of you for coming here, and all the people online who have listened, and we really hope that the report has the impact that we intend. So thank you all once again.